ಮಾ ಮುಕ್ತನ್ಸ್ ಬಂತ ಇಲ್ಲ ಆ ಕಡೆ ಬಂತ ಮದು ಮುಕ್ತಂದು What you think?
Have it tomorrow then.
Adjournments page wise, page 7, till number 17 to 22.
One, serial number 8. What do you want? Huh? Inmate has to argue. Huh? Counsel, okay. Have you informed the appellant? Counsel for the appellant. Respondent week's time. Release next week.
Page number 8, till number 23 to 26. Page number 9, till number 27 to 30.
Mr. Arun.
My Lord, for the petitioner here, my Lord.
Yes.
Sorry, I have to seek your lordship's indulgence once again. Like I said on the last occasion, while shifting the office, while renovating the offices were lost, first and second matter. And I was able to trace one file. My Lord, your lordship may kindly grant me 2 weeks so that it is done. I'm so sorry about this.
There are counsel for the petitioner present before the court through video conferencing and submits that he would require another week's time.
Couple of vacations, I'll do it. I'll do vacation sometime during the vacation, Lord. 2 weeks, your lordship may kindly grant me.
He would seek some more time to trace out the file and place file the inventory. Accordingly, list after 2 weeks.
Much obliged. Much obliged. Second matter also similar.
Same one.
Much obliged.
It's Samuel.
Serial number 3, I appear for the petitioner in this case. On the last date of hearing, I had submitted that since there's no instructions from the petitioner, I would like to retire from the case and sought time to send the notice. I have already sent the notice. However, the notice has come back to me unserved as the client has left that address. So I request for 4 weeks time because this is a matter which has been referred. So I have already asked instructions from the person who was referred saying if they can furnish the address to me, then I can send it across.
Counsel for the petitioner submits that he has no instructions to proceed with the matter despite issuance of reminder letters to the petitioner.
As well as a retirement notice also I had sent. However, that has come back unserved.
So the retirement notice to the petitioner.
Petitioner also.
It takes time. Release this matter after 3 weeks.
Obliged.
Yes.
Till number 4.
Time grant, find the inventory.
Number 5. Mr. Arjun Sawan.
My lords, I appear for the petitioner in this case also, my lords.
Ah.
In this case, my lords, to IN number 1 of 2023, my lords, my colleague had filed his affidavit. Therefore, we thought it might be advisable to file the petitioner's affidavit itself. So therefore, it has been sent. It is coming from London, my lords. So my request is that 3 weeks time may be granted. In the meantime, if the paper publication may be directed, I would be obliged, my lords.
The counsel for the petitioner seeks time as the affidavit of the petitioner is yet to be placed on record. And since the petitioner is residing in London, it would take some time to discuss this matter after 3 weeks.
Obliged, my lords.
Huh?
R1A to F on record. What is this not taking up? Appellant 2. Appellant 2 also has died. You brought a. No, have you brought LRs of appellant 2 on record? No. And which respondent has died? And one of the respondent has died, Yaro. Is it allowed? Have you amended? Huh? When is that order passed? No, why you go back to the Delhi? It's an old order. That must be a mistake. How many respondents are there? Your order matter one of them. 523, there is only one respondent. This order itself is wrong. It could be one, the sole respondent has died. Now, after that, IAs are filed, IAs allowed. Appellant 2 is brought on record. What about the appellant? My daughter dated 25/5/2023, correct? The 25/5/23, the application for bringing the LRs of the appellant number 2 and sole respondent was allowed. They have been permitted to be brought on record. When were the respondent amendment carried out? Out of those LRs, any of the respondent has died? ನೀವೇ ಹೇಳಿದಿರಲ್ರಿ. Counsel for the respondent submits that appellant number 2 and one of the respondent has died. So who was that who has died? By order dated 2/3/2023, Learned Counsel for the respondent has submitted the death of appellant number 2 and one of the respondent. However, by order dated 25/5/23, LRs of the appellant number 2 have been brought on record. But the submission with regard to one of the respondent having died is not clarified by the respondent, and so also the the LRs. ಇರದೇ ಒಂದು ರೆಸ್ಪಾಂಡೆಂಟ್ ರೀ. Just tell him, madam. You have made a submission that one of the respondent has died. The first respondent has died, Antira. LRs are already on record. Then why you make one more submission that the respondent died? Sir, either you don't read your papers, don't make your notes, and come and make some false submissions and creating confusion in the court. 2019 early application is allowed, LRs are brought on record, amended cause title is filed. So because of your one statement, and now the court has wasted 10 minutes on this one small case of orders. Are you sure one of the respondents LRs has died? Thank you. Learned Counsel for the respondent is present. He submits that his submission made on 2/3/2023 was with regard to death of the sole respondent and not the LRs of the sole respondent. Therefore, since the LRs are appellant number 2 and respondent are already on record, is this matter, what should it come up for? Admit agidya? Yes, just for hearing. Pass ಕೊಟ್ಟಿಲ್ಲ. Karnataka ಕೊಟ್ಟಿದ್ದಾರೆ instead of High Court. Marಕೊಳ್ಳಿ, the cost paid to the Karnataka State Legal Services Authority instead of High Court Legal Services Authority is accepted. Is this matter for hearing?
And you want to make a you want to make it point. But on the side, on the property, You are transacted.
Hmm.
Service, what are you offering? First complaint is one. That's a complaint.
Who's the fifth respondent? Now, have you seen the list? What do you say? Correct. Now, according to her, she has given the list 84 sites, I think, or whatever. Now, your contention is there are some sites still available. It will be dealt with in the final order if at all you succeed. Argue the matter on the main itself. Yes. Learned counsel for the appellant is present. Learned counsel for the respondent number 4 is also present. She has filed a memo dated 3/10/2023, furnishing the details of the sale deeds in respect of sites carved out in survey number 16/2 capital D, situated at Tavarakere village, Tavarakere, Hubli, Bangalore, South Taluk. Copy of it has been furnished to the learned counsel for appellant, who shall go through the same, make his submissions on the main matter, list this matter for hearing. After 2 weeks, all right, next week. Ganamaya. He's here? Bad. Early. Not well, like. You are filing wakalat for him. Tira. 14% Shri. How much time? How much time you want? The Ganga Annamaya is present before the court. Unfortunately, he is not keeping good health. However, he has paid the cost of rupees 7,800 for preparation of paper book. Registry was directed earlier. All right. Paper books to be prepared as early as possible, considering the advanced stage of the party in person. What about R1? R1 deceased process fee kodbekalla. Paid. All right. The process fee has been paid for issuance of notice to R1, registry to verify, and issue notice to R1. Agidya. Is this matter after 4 weeks? Party in person on date and next date over 9th November. What is this IA? 1 TI. Now, who are you? Who are you? R5 what? Mister, you are now putting up some construction. What do you say? There are counsel for the appellant is present. Counsel for respondent 2 and 5 are present. Since respondent number 2 is already represented, the question of issuance of notice to R2 would not arise. Registry to delete the office note. IA number 1 of 20 for TI shall be considered along with the main matter. This is the matter for hearing. Admission agidya. This is the matter for hearing after 2 weeks. Next roster, you take it. Yes. Maybe I'll take it up after some time. After I finish the first round, you can come. After I finish the first round, before final hearing.
Please.
You filed LR application to bring LRs of R1, A to E. Notice of Bekeno. He appears.
Serial number 12, Lord.
IA number, yes, 12.
Yes, Lord. I have already filed wakalat.
Yeah, I'll allow the application.
Please.
He's Learned counsel for appellant and counsel for respondent are present. IA number 234 of 2014 are filed to bring the LRs of R1 in the form of R1A to E on record by condoning the delay of 69 days and to set aside the abatement. Full stop. Notices have been served and the LRs have been represented through a counsel. Full stop. I have perused the affidavit annexed to the application. Being satisfied, the reasons assigned and cause shown, I deem it appropriate to allow the application. Accordingly, applications are allowed. Delay of 69 days is condoned. Abatement is set aside. LRs are permitted to be brought on record. The form of R1 within bracket A to E. Counsel for the appellant shall carry out the amendment, file the amended cost title by serving copy on the other side.
And let this matter be listed for admission, my lord, during next week. No? 2010 matter, my lord.
Admit agilla.
Illa.
Collected the list.
Several times dismissed for default. 3-4 times not dismissed for default, and ultimately it got restored.
What about 12.1 non-amendment? In 12.1, counsel for appellant seeks 2 weeks accommodation, same is granted. What about next? In 12.2, first order madadala, same order, delay of 130 days. Same R1A to E. Yes.
Not kindly grant a date, my lord. This 2010 matter, my lord.
Released on 12th October
Please.
for admission.
Great.
ಯಾವುದರಲ್ಲಿ this cannot wait for you to no you argue in this 12 and 12.2. You are not interested in 12.1. Okay, I will give it is listed on 12th. What do you want this court to do? Wait for your eternity? 2010 you have come and no see, that is your problem. What the client has to do? 2010 RSA, the suit is of which year? Suit ಯಾವ ವರ್ಷದ್ರಿ? ಮತ್ತೆ you do it, file your application. Yeah.
Serial number 13, my lordship.
Serial number 13.
I appear for the appellant, my lordship. We have been served the copy, IA copy through email.
Yes.
Kindly request for a short date accommodation for document.
All right. Take the speak on the mic that he can hear you.
Final hearing next week because the issue is of year 1984 and the concurrent finding of that. Those small sheds.
Where is this located? What have you been doing government since 2011? All right. Mr. What's your name?
Surendra YS.
All right. I will allow the IA and list it for hearing. Whether question of law is framed.
Yes, they serving the ninth.
Argue the matter next week.
For the not first time, once get a forest land.
So it's a forest land.
No, my lordship, they claim
One
initially,
acre, balance 1 acre is 40. And then this record unless sort of established course of this. Two and claims land in here and stop both. Both of them are recorded.
Suit is filed for what?
declaration. My lordship.
So,
On the basis of the land and they have examined declared.
so declaration is rejected.
My lordship, there,
Permanent injunction sought.
Also rejected. Just stop.
A similar matter, Madam argued. Forest, section 6, I think, and section 25 of the land grant rules.
my lordship, they initially started with the allegation that this is a forest acquired land and we have encroached it. When the survey was done and it was clearly bifurcated that this is not an encroached area and this land does not belong to forest, they again came up with another allegation saying that we created a bogus record and Sagoli Chiti and then claimed this land. These are the
So you have to overcome that. You argue, will put this matter on 11th October.
much obliged.
By then you prepare yourself.
Yes, lordship.
All but good. Yes. IA number 1 of learned counsel for the appellant and learned additional advocate general for R1 to 4 are present before the court. IA number 1 of 2023 is filed by the respondents for early hearing, copy of which has been served on the counsel for the appellant. Since the matter is of the year 2011, I deem it appropriate to allow the application accordingly. IA1 of 23 is allowed. Is this matter on 11th October for hearing
Much obliged, lordship.
at 2:30. 2:30.
2:30.
Yes. ನೀವು ಹಾಕಿದ್ರ ಅಪ್ಲಿಕೇಶನ್ IA number 12 of 2023 is filed by learned counsel for the applicant. Who's applicant now? R1, B and C. Huh?
Yes, yes.
So you're appearing for them. You filed wakalat. You filed wakalat. Applicant who's also representing the respondent R1A, who was acted as guardian or respondent 1B and 1C as they were minor at the time of filing the appeal, filing the wakalat. Full stop. This application is filed to discharge the applicant R1A as natural guardian for respondent 1B and 1C in view of the fact that 1B and 1C have attained majority. Is submitted by the learned counsel for applicant that he has filed Wakalat on behalf of R1, B, and C. In view of the same, the applicant we can tell R1 A is hereby discharged as the guardian of R1 B and R1 C. Yes, what else? What is the permission now? Fine. So you have filed application to continue. Senate counsel for the applicant has also filed an application to permit applicants R1B and R1C to independently prosecute the appeal on by themselves instead of being represented through natural guardian. In view of the fact that this court has allowed IA number 2 of 2023 and discharged the guardian, the applicants R1B and C are hereby permitted to prosecute the appeal by themselves in independent capacity. Yes. Senate counsel for the appellant has filed a memo reporting the death of appellant number 1 Gangamma, Srimati Gangamma, who died on 26/4/2019. Full stop. The appellants number 2A, 2B, 2C, and 3 are the LRs of appellant number 1. Please repeat. To see also you have written. The memo only there. It's corrected. Don't add. Are the LRs of appellant number 1 Srimati late Gangamma. In view of the submission and memo based on record, the appellants 2A, 2B, and 3 shall be treated as LRs of appellant number 1. Full stop. Senate counsel for the appellant is permitted to carry out the corrections in the memo by deleting 2C, which is wrongly incorporated. He is permitted to do so during course of the day. Solve. Otherly the same idea, no order. What about in that Gangamma is which respondent? Which appel? How without even your memo? ಇಲ್ದೇದನ್ನೆಲ್ಲ ಮಾಡ್ತಿರಲ್ರಿ ಸಿದ್ದರಾಮಯ್ಯ ಅವರ ಇದ್ರಲ್ಲೇ ಅಲ್ಲ ಎಷ್ಟೊಂದು ಕರೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಆಗಿದ್ವು. ಕರೆಕ್ಷನ್ ಮೇಲೆ ಮೆಮೋ ಮೇಲೆ ಕರೆಕ್ಷನ್, ಆ ಕರೆಕ್ಷನ್ ಮೇಲೆ ತಿರ್ಗಾ ಇನ್ನೊಂದು ಕರೆಕ್ಷನ್. ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ದಿಸ್ ಮಿಸ್ಟರ್ ಸಿದ್ದರಾಮಯ್ಯ? Without an application, how I should? You may believe the typist, but I cannot believe even your words. First portion of the discharges to continue in 14.1. If you file a memo, then I'll do that. Correct ag nod hakbek. Yes. ಯಾವ್ದು ಹಿಂದಕ್ಕ? The first matter or second matter? ಅದ್ರಲ್ಲಿ ಯಾರ್ಗ್ ಹಾಕಿದ್ದೀರಾ ನೀವು? ಇವತ್ತು ಹಾಕಿದ್ದೀರಾ? ಹಾ. So what is your name? ಇದೆಯಲ್ಲ MB Rajshekhar for R11. That's up to R11. Now R11, you're appearing for LRs of R11. Who was reported the death and who was filed application? So he has filed a wakalat for both the LRs. Nobody is now left out. That can be allowed. The Inandu, what is this? You have filed also appears for R4, but he has filed wakalat for R5.
This matter, 1255, I am on the environment. But I am intending to file forward for R4 also. Most of the matter, very action is now no more. Now, the memo has been filed, treat the other two as legal representative already on the not necessarily is stated. Now, see, the appellant has to bring the wife of that Mallikarjun's son.
So this holds good even for the first matter. Who's R1? Huh? Even R1 is ಇದು R1 ಆಗಿದೆ. How many LRs are there for R1? The form of R2 and 3 to be treated as LRs of R1. Who was no? Acha, she is not appearing. Then counsel for the appellant has filed IA number 4, 5, and 6 of 2021 to bring LRs of deceased R1 on record in the form of R1A. Along with two other LRs who are already on record in the form of R2 and R3. Full stop. Notice on the application has been served, but R1A is unrepresented despite service of notice. I have perused the affidavit. Next to these applications, being satisfied for the reasons so and so. Delay of 48 days is condoned, abatement set aside. the LRs of R1 are permitted to be brought on record as R1A. Full stop. Para. Counsel for appellant has also filed a memo reporting the fact of death of R1 and that R2 and 3 being already on record be treated as LRs of R1 along with R1A. Same is accepted and permitted. Learned counsel to carry out the amendment, file the amended cost title by serving copy on the other side. What about paper publication for R11? Madam, who's R11 in your case? Ah. So this Vishalakshi is also there in the second matter. Nobody has filed wakalat. Okay, then direct him. Huh? Vishalakshi unrepresented idharalri ಏನೇನೋ ಹೇಳ್ತೀರಾ ನೀವು. My question to you is in the connected matter whether somebody is appearing. You are making false submission. Keshav Murthy is appearing. At least you can see what is available in the cost list and make submission in the application. Then counsel for the appellant filed an application under Order 5 Rule 20. Take out service of notice by the substituted service through newspaper publication to respondent number 11 as she has exhausted sufficient time, but the notice is not accepted by R11. Hence, this application is filed. Being satisfied with the reasons assigned and cause shown, this application deserves to be allowed. Accordingly, it is allowed. Appellant is permitted to take out service of notice to R11 by substitute service through newspaper publication in Kannada Daily newspaper within inverted commas Kannada Prabham Mysore edition. Correct ಮಾಡಿದ್ದೀರಾ? Mysore edition, which shall be taken out on or before. What is next? What is 12? All right. A week's time granted to take note to the needful for issuance of notice to R12. Who's this? ನೀವು appear ಆಗ್ತೀರಾ? ಎಲ್ಲಾರ್ಗೆ. What are the names of the LRs?
Why am I on record?
Learned counsel has filed an application to bring the LRs of deceased number R12 in the form of 12A and B, and in view of learned counsel Sri MB Rajshekar having filed wakalat for these LRs of deceased R12, registry to show his name as counsel appearing for LRs of proposed R12 A and B in the cost list. We'll allow that application.
That's the overability is no more, madam.
Correct. ಅದಕ್ಕೆ ನಾವು LR ಹಾಕಿರೋದು application. IE number 1 of 21 is filed by the appellant to bring on record the LRs of deceased R12 in the form of R12A and B. There's so the notice on the application has been accepted by learned counsel, Sri MB Rajshekar, who has already filed power for the same party in the connected matter. There's a delay of 1164 days in filing the LR application. I have perused the affidavit annexed to the application, being satisfied with the reasons assigned and cause shown. The application is deserved to be allowed. Accordingly, the IA is allowed. Delay of 1164 days condoned. Abatement is set aside. LR of R12 is permitted to be brought on record as R12A and B. Counsel for appellant to carry out amendment, file the amended cost titles, and serve a copy of the same on the other side.
All 10 minutes. All 10.
Yes,
And finally,
for R10.
all 10, inshallah.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅವರೇ ಇದ್ದಾರಲ್ರಿ.
Everybody is on the
I have just now passed an order. You appear even in that case also you appear, she will save some money on newspaper publication. You want to undertake to appear in the connected matter for R10 Vishalakshi alva?
Now, ಈ second matter,
Hmm.
connected matter ಅಲ್ಲಿ ನಾನು undertaking
Vishalakshi. The first matter you don't want to undertake.
She is in the first matter of
ಅದನ್ನೇ ಮತ್ತೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. Will permit you to argue in the one matter, but you will not be permitted to argue for Vishalakshi in the other matter. Problem alla. That is a court's order. For you, it may be problem.
Only second man.
No, I will not permit you. I will not permit you. If you are going to undertake to appear for her in the connected matter, you better take notice for her in the first matter also. You cannot act. What is this? You have to be fair to the court. You are appearing in one, not appearing in the other. And newspaper publication, the cancel ಮಾಡಿ. Learned Counsel Sri M.B. Rajshekhar undertakes to file wakalat on behalf of respondent number 10, respondent number 11 in the first matter. The newspaper publication is for R11, R11 in the first matter and R10, the second matter for Srimati Vishalakshi, registry to show his name in the cost list.
What is Safari?
I number 1 of 2022 for paper publication in respect of R11 is hereby dismissed as not pressed. Oh. ಕೊಡಿ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಯಾರು ಇದ್ದಾರೆ ಅಂತ ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ. ಆಲ್ ರೈಟ್, ನೆಕ್ಸ್ಟ್. Four and 5 is in the connected matter 15.1 only. Memo is filed by the counsel for appellant to treat R4 and R5 as LRs of R3. Same is accepted. R4 and R5 shall be treated as LRs of R3. Necessary amendments and corrections to be carried out. Amended cost title to be filed by serving copy on the other side. ಇನ್ನೊಂದು R4 ಬೇರೆ ಇದೆಯಲ್ಲ, R4, R5. Learned Counsel Sri M.B. Rajshekhar has already filed wakalat for R5. He also undertakes to file wakalat for ಹೇಳ್ತಾ ಇರೋದು. Next.
Yeah. They will begin activity. For district. For lot of it. But since the appellant did not argue, appellant before the counsel for the start, did not argue my statement argument. We were one of the serious petition of right for all the right. Because the learned because party saying that it's a party. After the
Hmm.
Both the council is appearing before the grand court.
No representation. Suit is for what? Cancellation of sale deed. Huh? Who's in possession? From whom? And who are these? So what is filed in the execution court? Seek the judgment. What happened in the trial court?
The operating person is the
You are the plaintiff. You are the defendant. Which defendant? Sole defendant. Kamalamma. Hmm. So what happened to the suit? Suit came to be dismissed for declaratory relief. And 86 executed by 3 and 4 in favor of first defendant is void. So 3 and 4 remained absent, is it?
They have sold the property. There are 8.
No relationship.
There are no relationship.
All right. So this was taken up in appeal. Appeal, what happened?
Case of the appellant, that is a claim, first proceeds to decree the suit.
Because you are not addressed arguments. So where is the appreciation? Where is the points raised for consideration? Hmm.
The owner of the property.
The plaintiff is proved to be the owner. So you are held to be in permissive possession.
No, but I have been not finding mother of that sort. The transit appreciates the saving executed by my data. But there is a finding by the lower of that part of the architects. The cross examination that dependent number 2 and 3 have sold this property in favor of dependent number 1 and 2. They have also constructed a house. The dependent number 1 and 2 are also trying construction. That point of it's the same. That cause of action. He is in possession of that. Four colors are there. One more. Colors kindly refer to.
What is the extent of land purchased by you?
The extent of land purchased by he is Manoj Sadesh. Number 1, 15 into 20 months. Number 4 is 21 into 29.
It's a vacant site, is it?
But one, I should have one was already a construction was there. You know that regarding the saving in the year 1989, when the dependent of one and 2 started construction in item number 2. Now item number 2 is also being building has been constructed and we are deciding.
So on both item number 1 and 2, there is an order granted in favor of plaintiff
Yes, sir.
against you.
Yes, sir. But the lower appellate does not recommend the
Have you filed now? Not yet. They have served but not represented. You have served copy of it on the council representative.
Is appearing before the speaking court. I have read the acknowledgement also, and also be written. Also, the answer was also personal served. All in particular.
Current counsel for the appellant is present. There is no representation on behalf of respondents. Despite service of notice on them, who are none other than the LRs of the sole respondent. Current counsel for the appellant has made efforts to serve the copy on the counsel representing the respondents herein before the executing court, but despite receiving they have received? No, the counsel. Despite the parties receiving the notice and the counsel accepting the notice of this case, they have not appeared before this court to represent on behalf of respondents. However, the fact remains that an execution petition is filed. What is that number? You have stated so in your affidavit.
not binding.
The council submits that an execution petition number 11 of 2017 has been filed to execute the order which is impugned herein. Of the further contents that if the said order is executed, nothing would survive in this appeal. Full stop. In order to provide one more opportunity for appearance on behalf of the respondents, I deem it appropriate to list this matter on 12th. When is the matter? 12th. Released on 12/10. In the meanwhile, the executing court in execution number 11 of 2017 shall not precipitate the matter. To place this order there, and we'll come and appear. Siddhamalappa. Howದು? You can come then. You can move. Yes. Gopi. Call it together, Rust. But anyway, that will go to your benefit. We have the fact that your matter is admitted and it is emanating of the same judgment. Call it together. He will be at a disadvantage because of that. Now that you have brought it to the notice of him, it is up to him whether he wants to challenge that entry. ಮಾಡಿದ್ರೆ ಮಾಡ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ will hear you. You can produce that, argue on. Learned counsel for the appellant in both the matters are present before the court. Release this matter on 13th October. 13th October. In the meanwhile, let him see whatever you want to do now that you have heard what he said.
For 18 adjourned.
You're not Mr. Bandari. You're feeling better. Viral, na? It is in the air now. When I was infected last week, it's very difficult. Yes.
My lords, 19, my lords, I appear for the appellants in the matter. In RSA 1434, my lords, I have filed an IA to bring the legal aids of respondent number 1 on record. The office objection, my lords, is that death certificate is not produced, my lords. We have visited, the bank officials have visited the house of the respondent number 1. They're not giving us a copy of the death certificate, my lords. In fact, a memo was filed by R2. On that basis, we have got the LRs on record, my lords.
Memo was filed by R2.
R2, my lords. R2 had filed a memo.
Now, where is your IA? There is some compliance. That is the compliance is death certificate.
Death certificate, my lords.
Where is the respondent? Kulkarni? How many LRs are there?
Only one LR, my lord. His wife is being brought on record.
Wife?
Yes, my lord.
Yashodamma.
Bhagyamma, my lord. In RSA 1434, my lord.
1434. Bhagyamma service ಆಗಿಲ್ಲ ಹಾಗಾದ್ರೆ ಹೋಗಬೇಕು ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ
Notice ಹೋಗಿಲ್ಲ ಅಷ್ಟೇ.
The memo was filed by R2.
Memo dated 27/9/2020.
R2 ಹಾಕಿದ್ದಾರೆ ನಮ್ಮ memo reporting dated. You secure the death certificate.
My lords, we tried. They are not giving us the copy, my lords.
Who's not giving?
From their family, because this is Canara Bank is the
Go
appellant.
to the BPMP wherever the death has happened and obtain. What is this? Our family ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾರ ನಿಮ್ಗೆ ಅವರು. You don't know how to obtain death certificates.
We'll try, my lords. Otherwise, we'll try. 2 weeks time.
Because we have to ascertain whether the R1 is the respondent is not collusion. You are for whom? R1 died. LR, you are not filing wakalat for LR. Why they have not come? Huh? All right, then I will allow the application. Barkole. The objection raised by the registry on IA number 1 and 2 of 21. Akhil. You have not filed for delay.
Delay is also filed, my lords. For setting aside abatement, IA2 is filed. For condoning the delay of 160 days. Two applications are filed.
Separate application to be filed for condonation of delay. 2021. Issue notice on IA number 1 and 2 of 2021. Office objection is overruled in view of the fact that the respondent number 1 has reported the death of R1 and learned counsel is present before the court confirms the death of R1. You notice
Much of it.
18. ಯಾವಾಗ ಹೋಗಿದೆ ಇದು? You are the appellant. Who's that one of the Who's that one of the respondent? Specific ಕೇಳ್ಬೇಕಲ್ಲ specific. When you confirm next week you submit. ನಾವು ಅದು ಒನ್ ಆಫ್ ದ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾರು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಕರೆಕ್ಟ್ ಆಗಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ಬೇಕು. Shall I note down? Then why you want to when you are not sure? Next week ಅದನ್ನೇ ಹೇಳಿ after obtaining instructions. Yes, Bandari. Okay. Day after Akhan. Letter get well day after tomorrow. All right, release this matter day after tomorrow. 5th. Arti. That is your friend, Mr. Nayak. Where is your friend? Nayak? ಇಲ್ಲ ನೀವಿದ್ದೀರಾ? I saw you. ನಾಯಕ್ ಅವರಿಲ್ಲ. This review petition is filed by the appellant in RSA 2531 of 2006. These review petitions were the defendants number 1 and 2, Allah. Alvenri Jagdish Chari. Defendants number 1 and 2, you were. Defendants number 1 and 2 before the trial court in OS number 946 of 1990. Full stop. The review petitioner is seeking to review the order passed by this court in RSA number 2531 of 2006 on the grounds of discovery of new and important matter of evidence, which, despite exercise of due diligence, if obtained, but was intentionally and deliberately not produced by the respondents. Full stop. Para. Plaintiff had filed a suit in OS number 946 of 1990 for the relief of partition, separate possession, and half share in the suit scheduled properties, and for permanent injunction to not alienate or encumber the suit scheduled property against the defendants. It was a case of the defendant number 1 that her grandparents, late Narsimaya and Chaudamma, had 2 daughters by name, Srimati Muniyamma and Srimati Gundamma. And that the first defendant plaintiff, first defendant, plaintiff is the daughter of Muniyamma. And that the defendants are the children of Srimati Gundamma. It is also stated that the grandparents did not have any male issues. Full stop. The grandfather of the plaintiff and defendant, late Narsimaya, was the only son of his father, who inherited immovable properties consisting of dwelling house at K. Chudahalli, Uttarahalli, Hobli, Bangalore South Taluk, mentioned as Schedule A and B properties. And C schedule properties. There were several contentions raised between parties in the suit proceedings. With regard to the ancestral properties not being the ancestral properties of Narsimaya as claimed, and the suit settled properties were self-acquired properties of defendant's grandmother, Srimati Gundamma Chaudamma. It was also claimed that a last will and testament came to be executed by Chaudamma, bequeathing the properties and other items possessed by her in favor of her only daughter Gundamma, creating life interest in her favor, and after the death of Gundamma, her grandsons, the petitioner and second respondent herein, succeed to the properties bequeathed under the will. The suit filed by Srimati Muniamma, OS number 946 of 1990, came to be dismissed against the third defendant. And the suit came to be decreed with regard to half share of the suit schedule property. Defendants altogether were entitled to half share in the suit shell property. And an order of permanent injunction was also granted restraining the alienation of half share of plaintiffs in the suit shell property. Being aggrieved by the judgment and decree passed in the suit, OS number 946 of 1990, the defendants number 1 and 2 therein, who are the petitioners herein, filed an appeal in RA number 84 of 2003. And the same came to be dismissed on 21/7/2006. Being aggrieved by the dismissal of the first appeal preferred by the defendants 1 and 2, the second appeal came to be preferred, challenging the judgment rendered by the first appeals court, dismissing the appeal of the defendants 1 and 2, dated 9/8/2007, at the stage of admission itself. Several contentions were raised in the second appeal by the appellants bar petitioners herein, by contending that the erstwhile Narsimhaya had not possessed any immovable property during his lifetime, and that the said Chaudama was the owner of property bearing number 72, property number 42, which is an Inam land. And therefore, the order passed by the first appellate court requires modification and reversal of the judgment in favor of the defendants. However, despite the government contentions put forth by the learned counsel for the appellant defendants 1 and 2, the second appeal came to be dismissed. Holding that the decrease of the suit in favor of the plaintiff, that she was the daughter of Muniamma and granddaughter of Narsimhaya and Chaudamma, and also suit properties belong to Narsimhaya, came to be affirmed. But the grievance of the defendant petitioners herein was that the suit shell property which belonged to Chaudamma was not at all looked into, and no finding was given at any stage by all the three courts, that is the trial court, the first appellate court, and this court in second appeal. Stop. It is the vehement full stop para. It is a vehement contention of learned Counsel Sri Devanand, who in his regular style of arguments, erudite submissions, contends that the plaintiff Muniyamma, who has filed the suit in OS number 946 of 1990, is an imposter, Muniyamma, and she has got no relationship whatsoever with the family of Narsimaya and Chaudamma. All this defense was taken up in the written statement. Evidence also was adduced before the trial court. And including placing materials before the trial, both oral and documented. The trial court, as stated earlier, decreed the suit in favor of the plaintiff by allotting half share in the suit-shell property to the plaintiff as well as defendants, which on challenge by the defendants 1 and 2 in RA number 84 of 2003 came to be dismissed on 21st July 2006. Affirming the judgment and decree of the trial court. The challenge made before this court in the regular second appeal in RSA 2531 of 2006 by the defendants 1 and 2, among the writ petitioners herein, also did not yield much fruit in favor of the defendants 1 and 2. And accordingly, the appeal filed by the defendants, second appeal filed by the defendants, also came to be dismissed. Upholding the judgment and decree passed by the trial court and the lower appellate court. Stop. Now, by virtue of this review petition, the appellants in RSA (2531) of 2006, who were defendants number 1 and 2 before the trial court, are before this court making efforts to impress upon this court that the judgment passed by this court in second appeal requires to be reviewed. For the reason that there is a discovery of new and important matter of evidence, which despite due diligence is obtained, but was intentionally, non-deliberately not produced and placed by the respondents before both the courts. It is the vehement contention of learned counsel Sri Devanand that there has been an error in the reasoning of the trial court, the first appellate court, and this court. Therefore, the matter requires consideration of review in order to rectify the miscarriage of justice and consequently render justice to the parties. Learned counsel further contends that this court has the inherent jurisdiction to rectify the error committed by the court. And therefore, the review petition would be maintainable. Full stop. Learned counsel has vehemently contended that the trial court, the first appellate court, and this court in second appeal have not considered the aspect of whether the plaintiff Niyama had any relationship with Narsimaya and Chaudamma. And contends that said Niyama, the plaintiff before the trial court, in fact, did not have any issues. And all such claims made by the plaintiff are false and frivolous without any material documents, both oral and documentary, and hence the same could not have been believed to be accepted as truthful by both the courts below as well as in the second appeal. Stop. He further contends that in the second appeal, the aspect of the plaintiff being not the daughter of said Niyama has not been appreciated, and therefore a serious injustice and miscarriage of justice has been committed. Serious error and miscarriage of justice has been committed to the defendants petitioners herein. He further contends that when the plaintiff is unable to establish her relationship with Narsimaya and Chaudamma, and she being the daughter of Niyama, the question of decreeing the partition suit in our favor to an extent of half share is totally erroneous. The same requires to be reversed and set aside, which has been ignored by the first appellate court and this court in second appeal. Having not looked into these crucial aspects by this court in second appeal, the present review petition has been preferred. Judgments. In order to substantiate his contentions, the Learned Counsel has relied upon the following judgments. I'll list them 1 to 5. Stop. The sum and substance of arguments of Learned Counsel Sri Devanand is that there is a mistaken error apparent on the face of record of this court, which has warranted the filing of this review petition for correcting the same. He contends that the jurisdictions of review can be exercised by this court to rectify such errors which is apparent on the face of the record and substantial to the point of law. On the basis of submissions made by the learned senior counsel and the judgments relied by him, he seeks indulgence of this court in reviewing the order passed by this court in second appeal. Which is your best judgment, Mr. Devanand? Which is your best judgment out of all those?
I'm saying what the most of the jurisdiction report, but as well, the court should not negate the right of appeal. I mean, the right of appeal is what the manner in which it has been exercised by this court by not going into the court. If you come to court was effective side because of the fact that the questions to decide whether they are not going to the record. I am observing my words. He likely doesn't have any good basic or record at all. That takes that was by me. Fourth question of the law. That is the fourth question. All the three questions are going to be asked.
Then counsel further contends that the core issue has been ignored even by this court with regard to the subject matter of the issues contained in the suit at first appeal as well as in the second appeal. So therefore, review is an imminent requirement to be considered, and the judgment requires to be reviewed, reopened, and said 4 issues would have to be considered by this court. As according to him, this court has set its eyes on the relevant core issues and the question of law put forth in the appeal memo by the appellant defendants. Full stop. Per contra, there are counsel Sri Nayak, N.R. Nayak, appearing on behalf of the respondent plaintiff, vehemently contends that this review petition is not maintainable in law. For the reason that the review petition has been filed after a lapse of 11 years, 6 months, and 17 days. The delay in filing the review petition and the humongous number of days of delay has not been properly explained. It further contends that the properties have been divided and the parties are in respective portion of the apportionment made by the Deputy Commissioner to effect the partition in FTP number 3 of 2007. And the Commissioner's report has been accepted by the trial court on 26/8/2017. He also contends that nothing survives now for consideration in view of the fact that the parties are in respective possession, peaceful enjoyment of the suitable property of their respective shares. Next para. Learned counsel Sri Nayak vehemently contends that the review, there is no scope for reviewing the order passed in the second appeal. He also contends that the scope of review under Order 47, Rule 1 is very limited and cannot enlarge the scope of review. Section 114 of the CPC. Learned Counsel further contends that the entire arguments addressed by the Learned Counsel for the review petitioner is on the basis of the merits of the case pertaining to whether the plaintiff Srimati Punyamma whether had any subsisting right over the social property and was whether the daughter of Punyamma and whether she is entitled to equal rights for partition along with the defendants number 1, 2, and 3. These aspects of the questions and arguments put forth by the Learned Counsel for petitioner cannot be agitated in a review petition for the simple fact that all these aspects were urged and answered by the trial court as well as the first appellate court, and having considered both this court in second appeal negatived the contentions of the review petitioners bar appellants. Therefore, the question of going into further reasoning of the orders passed by this court in second appeal is beyond the scope of review under section 114 of CPC, read with order 47(1). If at all the review petitioner has any grievance of this court having not considered his contentions in the second appeal as put forth in the review petition herein, he would certainly have a remedy to challenge the same before the appropriate forum known to law. Learned Counsel further contends that in a review petition, this court cannot conduct a roving inquiry and rehear the appeal freshly to consider the contentions put forth by the review petition. This aspect of rehearing the merits of the matter or any aspect dealing with the merits of the matter in the review petition has been scuttled and deprecated by the Honorable Apex Court and this court in several catena of judgments. Learned Counsel also contends that the review petition is also not maintainable for another reason, that the counsel who argued the second appeal is not the counsel who has filed the review petition. Therefore, on this ground, also the review petition deserves to be dismissed. Full stop. Learned Counsel further contends that this court in second appeal has considered in detail the contentions put forth by the review petitioner, and having adverted to the impugned judgments of the trial court as well as the first appellate court, impugned judgment of the trial court as well as the first appellate court, having not found favor with the appellant, dismissed the second appeal by confirming the judgment and decree passed by the trial court and the first appellate court. Therefore, there is no further scope of rehearing, reappreciating, or fresh hearing of the second appeal in the guise of a review petition. Stop. Learned Counsel relies on the following judgments in support of his case. Five judgments ಇದನ್ನ ಬರ್ಕೊಳ್ಳಿ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ. Section 114 of the PPC, which deals with review, reads as under. Extract section 114 CPC. Order 47, Rule 1. Reads as under. Strike that also. Admittedly, in the present case, there is a delay of more than 11 years in filing the review petition. I have perused the affidavit annexed to these applications for condonation of delay and the review petition. When any application is filed seeking condonation of delay, it becomes the duty of the person claiming the delay to explain it in a proper manner. Each and every days of delay caused in filing the petition. Though the courts have been taking lenient view while condoning delay if there is a small amount of delay. But when there is a large number of days of delay, as in the present case of 11 years, then there has to be proper explanation which would call for condonation of delay by this court. And the reasons assigned to be an acceptable one. In the case of Isha Bhattacharya, Jia Bhattacharya, the Honorable Apex Court has said that in normal circumstances, the courts would have to take a pragmatic view for condonation of delay and not take into hyper-technical reasons for dismissing a petition on the ground of delay. But however, at the same time, has come down heavily on such litigants who sleep over the matter, do not bother to litigate and come before the court at the earliest point of time, and has rejected those petitions where the litigant has slept like a Kumbhakarna within single inverted commas. Under such circumstances, the delay was deliberately not condoned because of the conduct of the litigant, thereby has laid down the law as to how a delay has to be dealt with by the courts upon facts and circumstances of each case. In the present case, admittedly, there is a delay of more than 11 years. In a review petition, what is required to be considered is not to reappreciate and reanalyze what has been already decided by this court in second appeal, but to review the order on the ground that there is apparently inherent error committed by the court for reconsideration of the same. So this court will have to primarily see if there is any error committed on the apparent on the face of the record, which calls for a review of the order passed by this court in second appeal. On a careful perusal of the order passed by this court in second appeal, this court has dismissed the second appeal at the stage of admission itself, having not found any merit in favor of the appellant, bar review petitioner. It is the sum and substance of arguments of the learned counsel for review petitioner is that this court has not appreciated the genuinity or authenticity of the plaintiff to be the daughter of Niyama, which has been ignored completely by all the courts, including this court in second appeal. Therefore, he wants this court to go into the aspect of the genuinity of the plaintiff being the daughter of Srimati Niyama. Well, with great respect, this court is of the humble opinion that this aspect cannot be gone into in the review petition, which has already been decided by the trial court, first appellate court, and the second appeal. It is straight law that while dealing with the review petition, there is no scope given to this court to go into the merits of the matter. Like dealing the review petition in the form of an appeal. Of course, the review petitioner will be entitled to challenge the same on merits if you want to prefer an appeal. But to consider a review, he will have to primarily establish before this court that there is an apparently inherent error committed by this court warranting interference in the review. Having perused the impugned order, having perused the second appeal, so also the governments made in the review petition and the submissions of the learned counsel of both parties. I do not find any cogent reason made out for considering this review petition on the ground that there is any inherent apparent error committed by this court in the second appeal. Therefore, this review petition is devoid of merits and is liable to be dismissed. Accordingly, I pass the following order. This review petition is dismissed not only on the ground of inordinate delay and laches, but also on the merits. Stop. Parties to bear their own costs. Yes.
Really?
From Suit of the plaintiff was decreed. First appellate court affirms, reverses. The concurrent finding on divergent. So you are the plaintiff. Hmm. Whether Mr. Gangadrappa is ready. What is the ground for reversal by the first appellate court? Ah. Plaint, huh? Oh. Mr. Gangadharappa, I have this matter next week because everything is in Kannada. So the plaint is in Kannada, the judgment is in Kannada. Some extent for me to understand it may take, I do not want your efforts to be scuttled because of my. So you take chance next week. I will list it on 13th and then adjourn it after. Otherwise, I had all the time to hear both of you. Learned counsel for the appellant and the learned counsel for respondent are present. Ready to go on with the matter. However, release this matter on 13th. Will have to be soon. All. Yes. You're ready. Pass it over. If they come in the afternoon, I'll hear you. ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ, ಅವ್ರು ಮಾಡ್ಬೇಕು. Pass over, let us see.
My lord, appear the appellant, my lord.
Yes, partition suit.
Yes, my lord. My lord, in the connecting matter, the appellants have, in the connected matter, they have filed an application for bringing LRs on record, my lord, of the respondent number 2 therein. So,
Yes, who are you appearing in the connected matter?
my lord, I am not appearing for anyone in the connected matter, my lord, but the party is the same as the 1738 of 2007. My lord. I am the respondent number 2 there. The appellant herein is the respondent number 2 therein, my lord.
Then you take notice.
Please, my lord.
You have filed for the LRs of R2.
No, my lord, it is filed by the appellant therein, who is the R2 herein, my lord.
Correct, Ray. You are
Yes,
appearing for, you are the appellant who's R2 in the connected matter.
Yes, my lord.
But you have not filed wakalat.
No, my lord.
Why you are not filed under? No.
So, my lord, we'll take instructions from the clients. They have not yet come to the office. Kindly, a week's time may be granted, my lord. We'll file
No. What is there for you to take instruction when you are already appearing for them in the first matter?
My lord.
Same procedure. Where's the question of taking further instructions?
Yes.
Suppose, if they keep getting, dead, then you keep taking instructions. You're already appearing for the LRs in the as an appellant in the first matter.
Yes. My lord, we'll file the work.
You argue the matter, filing wakalat is only a ministerial act. You can do that. I'll permit you.
My lord, my senior is not well today, my lord. He was unable to appear. I kindly.
Who's your,
my lord?
who's your senior?
Mr. Shanmukappa, my lord.
I'll bring him in the afternoon.
My lord, my lord, he is not keeping well. He's not able to come today, my lord.
You can come on VC.
Please, my lord. Please, I'll.
You're also not ready. He's the appellant who's up for respondent number 2. Who are the LRs? 2A and G. A to G. ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. ರಾಜಶೇಖರಪ್ಪ. R2A. In client ಹೆಸರೇನು?
My lord.
What is your client's name?
My lord, Dodabayana, my lord.
R2A or A? Dodabayana. You're appearing for Dodabayana.
For LRs of Dodabayana, my lord.
ಅದ್ರಲ್ಲಿ ಕರೆಕ್ಷನ್ ಆಗಿದೆಯಾ ನಿಮ್ಮ ಅಪೀಲಲ್ಲಿ? ನಿಮ್ಮ ಅಪೀಲಲ್ಲಿ you brought LRs on record?
Yes, my lord. We have filed an application to bring the LRs on record. Yes, my lord.
In your appeal?
Yes, my lord. In 1738 of 2007, we have filed the LRs application, my lord.
All right, then I'll allow his application. You come on record.
Please, my lord.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the appellants in both the matters are present. In RSA 1822 of 2007, counsel for appellant is filed. 3 IAs, IE 1, 2, and 3 of 18. On record. the LRs of deceased R2, the form of R2A to G. Similar application was filed in the connected appeal RSA 1738 of 2007 by the appellant. Counsel for appellant is representing the said seized persons LRs. Full stop. In view of the LRs have already having come on record for the appellant in the connected appeal, there would not be any impediment if the applications are allowed and the LRs are permitted to come on record in this appeal. Accordingly, these three applications are allowed. The delay of 1006 days is condoned. Abatement set aside. LRs of R2 are permitted to be brought on record as R2A to G. Learned counsel, yaar name Mr. Shanmukha.
Yes, my lord. Mr. Shanmukha, sir.
Learned counsel Shanmukha undertakes to file wakalat on behalf of R2A. Only R2A. What about this Rajshekharappa for R2B and B to G? Team office in our
My lord,
I don't think so. He's the respondent R5 to 10. Okay. So Shanmukappa for R2A and Taki Master. Counsel for appellant to carry out the amendment, file the amended cost title. Release this matter next week. Veena Hegde. Pass over.
25. I'm appearing for the appellants in both the cases.
Yes.
I think respondent is Mr. Sheshgiri Rao, who is appearing for the respondents, contesting respondent.
Yes.
It may be taken up on some other day. I'm ready to argue the matter today. I have some some difficulty. Tomorrow it can be taken up. I'm ready to argue the matter. If your lordship can give a time tomorrow, otherwise it has to come after vacation. Madam, I have some difficulty next week. Any day this week, madam.
All right. At request of learned counsel for the appellant, respondent is here.
No, he's not. Mr. Sheshgiri Rao appears for the
appellant.
Chikkana.
Release this matter on 6th. Arne Tarik.
Agli, son.
There's no representation on behalf of respondent.
In fact, my lord, in this matter, instead of hearing the entire appeal, we have filed an application. It is only a question of what is the remaining extent belong to the appellant, sir. The trial court has given a finding. Since we could not come out with the actual extent of the land, I could not grant the relief of declaration and injunction again. And my lord, we don't want their property. It is adjoining property of the
joint memo ಹಾಕಿದ್ರೆ ಆಯ್ತಲ್ಲ.
ಅಯ್ಯೋ ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ ಏನಂತ ಒಂದು ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ಸ್ವಾಮಿ ಒಂದು ರಿಪೋರ್ಟ್ ತಗೊಂಡು ಅಪೀಲ್ ಮೇ ಬಿ ಕ್ಲೋಸ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
What is your suit filed for?
Suit for declaration and injunction, madam. The trial court had given a clear finding. Since I could not provide the actual, dimension of the property, I could not grant the injunction, declaration and injunction. Madam, we don't want their property. What remains?
To argue on Friday.
Friday, madam, please. Grateful manners.
Okay.
Yes, Mr.
I appeal for appellant in this case, my lord. But on record counsel is not keeping well, my lord. Kindly have 1 week, my lords. Minutes already. He is not keeping minutes. ಕಣ್ಣೇನೋ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಂತೆ. ಇನ್ಫೆಕ್ಷನ್ ಆಗಿದೆ.
So you argue the matter today.
He is not keeping while minutes on record counsel.
Cannot help it. He's not coming. I'm going to dismiss the appeal. Pass over. Pass over. ಕರ್ಕೊಂಬನ್ರಿ ಅವ್ರಿಗೆ ಕೌನ್ಸಿಲ್ ಕರ್ಕೊಂಬನ್ನಿ.
Kumar Gokakar. 27. Number 27. Ravi Kumar.
Pass over.
38. Teres.
Shankar, yes. PC Sunita. Pass over.
59.
Okay. You have not argued a single matter before me. Why? You should argue, madam. You should take the opportunity and start arguing. Otherwise, you will only keep taking adjournments. Nagaraj, BS Nagaraj. List it on Friday. You argue. Or next week. Huh? Next. Released next week. At request of Learned Counsel for the appellant. No representation for respondent. Deshraj. Huh? Took time last. ನೀವು ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್. ಎಸ್ So ಅದು ಹಿಂದ್ಗಡೆ ಇರೋ ಸೈಟ್ಗೆ there is no other access. ರೋಡ್ ಇದೆಯಲ್ಲ ಇರ್ಲಿ. Have you seen the photographs? You have not seen.
What is produced in the
So this is appeal by whom? Your plaintiff.
no, I am the ಅದು ಡೆಡ್ಲೈನ್ ಆಗಿದೆ ಅಲ್ಲಿ ಅವರು ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಕನ್ಫರ್ಮ್
Have you seen the photograph? See the photograph. It is in some village, is it?
Yes, yes, yes.
Must be just some ego issue between the parties. If that is the. It is a small gully which goes. So I think on the north and south there is a road. So you can go that way and you sit out behind your house or in front of the house. The photographs ಸರಿಯಾಗಿ ಇಟ್ಕೊಂಡು ನೋಡ್ರಿ, ನೀವು holding it wrong way. I gave you the correct way. So even if the gully is there is a drainage which is passing by. If he is even encroached some amount of by putting sajja. ಏನ್ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ? ಉಪ್ಪಾರು. ಅವ್ರ ಮನೆ ಕಡೆ ತನ ಹಾಕಿರೋದು. All right, anyway, now you find out with your client if he is agreeable to use that passage which is already drainage. I don't think you cannot now pass by. If you can use it, otherwise you argue the matter. We'll go by whatever on the merits. We'll discuss the matter on merits.
I'm discussing with my client.
Tomorrow? Time ಬೇಕಲ್ಲ. We require some time to check with his client. He is I don't know where is that place? Which place is that? Huh? All right, I will list it on Monday. Monday. Learned counsel for the appellant and counsel for respondent are present. Learned counsel for the appellant submits that there is a small passage which is in dispute, which consists of a drainage. So according to you, in that passage, he has put up his wall, is it?
Yes.
ಇದೆಯಲ್ಲ. You want whether the trial court has ordered the demolition of the compound wall also?
ಪಂಚಾಯತ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
Sir, please keep quiet. I'm asking her and she's telling you are screaming on top of your voice. All right, you both argue, then I'll pass orders. Keep quiet. The counsel for respondent to find out, to clarify from his client whether it is acceptable for any settlement for both parties to amicably reach their respective portions without disturbing each other. To report settlement, if any, or to further argue the matter, released on 9th October.
Pointer still number 24. So now Akul.
You argued this matter earlier? No. Where is your opponent? What is this suit for? Ah. Ah. Seeking partition also. See.
The share is claim that the shares. Well, in so far as the declaration, there is no situation in so far as the area is the declaration that asking what we declare in our asking is अंदर इस प्रतिवादिया करता है कि बहुत कानून में दे रहे हैं काम खेलने की प्रतिवादिया करता है बहुत कानून मारो आ रहे हैं आदमी आगे अभी प्रतिवादी करा रहे हैं तो और करेंगे दे So, here is darling.
You're the plaintiff. So your suit is dismissed, confirmed by the first appellate court. Hmm.
You cannot look at kindly.
Paper book idea, ma? Yes. Hmm.
There was a partition that there was was in the possession of one of the witches. Secondly, that information happened. The relative was a mind and they of these others, the and the affixed signature that communication one and subsequently that the Vikal Patra partition deed itself. It was made by the it must have been this most partition deed that has been got from this that people and this this mother that it also said they are going to understand they will do particularly that probably should be told. They are not going to discharge that duty that they have themselves accepted by the other. Subsequently, the fact that it is a partition also because very happy. That was a situation. He was there. So it was there. He was declared that the connection respect to the social property that it is property. All understood by them. He had a one day, and the speak, and the primary relation. ಸ್ವಾಧೀನ ಸ್ವಾಧೀನ ಈ ಕಾರ್ಯವನ್ನು ಹೊಂದಿರುವ ಆಸ್ತಿ ಮತ್ತು ಬಾಧಿಯರ ಆಸ್ತಿ ವಿವರಗಳ ಮತ್ತು ಇತರ ನೋಂದಣಿ ಕ್ರಯಪತ್ರಗಳು ಆಗಿರುತ್ತದೆ. ವಾರಿಗೆ ನಾವು ಹೇಳಿರುವ ವಿಸ್ತೀರ್ಣದ ಆಸ್ತಿನ ಅವರಿಗೂ ಅಂದಾಜು 90 ಕೋಟಿಯ ಜಮೀನು ಬಂದಿರಬಹುದು. ಅದನ್ನು ಹೇಳಿರುವಷ್ಟು around 19 Guntas had fallen to the share of the probably around 19 Guntas had fallen to the share of the later claims that it is position of the entire certificate. Not in possession. Probably lying to the south of the south of the purchase these lands from Karnataka and Proceedings. In the aspect that without knowing whether that had been fallen into the share, a salient has company executed. That makes us is completely on the basis of power. When we put that salient agreement, then absolutely no identification of the property has been done, no identification of the rights to the done. Apart from it, it is all the basis of profits is fallen into the share of the profits. 4.5 million deal that has been reached by their
Have you questioned it?
Yes. On this, right board. One can help that. Since it is claimed that the property, the existed in the northeast protected of its father, he also have produced the additional responsibility has been asked upon the lady. If the lady has specifically said that it was not what comes to the government that property the partition B is of this. Okay, why not that there was a partition? This whole. Rather, what state wants to be brother? If the brothers are not parties. Because the unit number 2, unit 1 and 2 are purchases from purchases of both the states. Purchases with respect to the have determined as the share which portion of land would have fallen to the share of which.
Where is it asked for?
There. They are there. That's It's on the basis that the party should be, on the basis that it is claimed that the party should be. It's a question of the law. And if the basis.
Have you made all the parties to the proceedings? Then how you can ask for partition? You have not made all the joint members of the family. Then whether all the properties are included.
The brother has come as witness.
No, I am wondering about your framing of the suit itself. You have sought for declaration to declare that it is ancestral property, but you don't ask what is the share of partition you want in the property, and how many of your other family members are there. What are the total properties? If partition is already happened and the purchaser has purchased, whether that has to be declared as null and void. Have you sought for such a prayer? Padilla. So what are the issues? Let us see. So the defendants are purchasers. So your brothers and sisters are not there as parties. How many of your brothers and sisters are there? And mother, father were not there at that time. So admittedly, you are not in possession.
I am in position. I claim that I am in position for the entire property. And that can see and
That is admitted or disputed. That is admitted or disputed. When is this suit filed? 9. So even according to you, there is a sale deed in 95, 96. And defendants 1 and 2 are in possession. Yours. Correct. And you are seeking for that sale deed not binding on you. So that means you are not in possession of the 20 and 19 guntas. So which property you are in possession?
For speech over we constructed position again that data again the stress. And we and my brother My brothers have sold about 19 minutes. The IT market is private, most savings are not private. Because the property, the entire property belongs to the house. But the savings did not have happened to my claim.
I agree for a relief of declaration. For partition, you're supposed to say you're in constructive possession. Have you said so?
I said
But it runs contrary to your own prayer. Because you're saying it is sold by your brothers. And you have made only them as a party. Defendant 1 and 2 are purchasers. And you are seeking that sale deed to be not binding on you. Doesn't it run contrary to your own? No, I am not asking. You cannot obviously improve.
said I need to answer.
Yes.
Claim that is the power. He also claimed that it is a power.
That evidence is with your mother. And that, all right, when such a statement is made in the written statement, then you ought to have amended your prayer and say, okay, grant me this partition of amount, so much share to me. So whereas that has not been done by you, you're only seeking alternative relief of partition. How do you value your suit? For partition, for declaration, or for injunction? All right. How this court can grant partition when there are no parties, family members? All right, let's see how the court has dealt with it. First appeal. 35 reason starts at para 7. Yes. Hmm.
That they will take position to the by application before the so that would change against which you could appeal before the system comes. Not at the same time. So much properties and so much properties it's social property. This is the property of the place of the place is for regulation. Social property. Not the right of this. I think the conflict things from the degrees are not made. On the other hand, say that and going for was literally one thing that very contrast and the name of the and when it has been noted up and you want the name of the 57 people 1990. When the 20 we survey number 36 by 3 from KS value and not that mentioned and equity is situated towards southern side of Also, P1 and P2. The utilities have produced. There is a saying that if P1 and P5 and produce complete tax receipts, which are marked as P1 to P7 and are not distributed again. This is here. This is not the but the commissioner has very revenues, but appear against some other now, the government arises to make created by has got able to write clearly in favor of the business. Yes, alone got right and the self-reservation, the candidate has not taken how he acquired the supervision. So the evidence appeared to come that at the time of the death of his father, the land parents were only 1 acre. His family has got other property. His friends were affected partition. So here, he stated the social property for a share and really went to the class of them. In the number was sold by his father very long. His brother what? He had from one village to God. He didn't want to that of his God and he got 5 items of land. What similar law? Find this. After the experience, what if they use partition they have taken the 3 years after not only what which share the parent has not stated that the party should be in the parliament. Then parliament has not been produced by the parent to prove that we want the social property under the party. I need the parent has not needed that we got the social property. It has not been so and what the family is more than his right. Dependent we are one red period takes that times 2 number. What is the share of the people? But another is Yes. There should be one of the evidence. Evidence is not part of it.
Who's asking for part? Defendants are not asking. Why they will produce? You are asking. Also, it says that you have purchased some 20 guntas and 30 guntas from whom? You have purchased, is it? Some portion. So apart from those sale deeds, you are asking for other portions.
But it also calls, but my name is that
What is the total extent of land? Which 1 acre to 36 bar 3, 1 acre 12 guntas. Now out of that 1 acre 12 guntas, you have purchased 20 guntas only. So the remaining portion is to be partitioned. So you purchased this from whom? One of the brother. Why did you buy it from your brother? You could have just asked for partition. That is what you are doing now. I think some totally it is a improperly drafted petition suit, I think. So that is upheld by the first appellate court. What you can do in the appeal stage? At least first appeal you could have done something, but that also I think no scope. Yes, what is your argument? Huh? Next date, Nale. She cannot come and wait for your senior every tomorrow. Now, madam, what happened to that extent of land which you had purchased? 22 guntas. It is with you. So that. No. Oh, you are. That's not disputed. So they have admitted that you are owner of the 22 guntas. But where is a declaration in that? What is the suit schedule property there? 30. So your 22 comes.
The remaining portion of 30 guntas, I am receiving on declaration.
So in your portion which you have purchased, you are in possession. You are not being disturbed. You didn't seek. So you didn't seek for any relief in that portion of what you are in possession and your ownership. Nale martira? Monday. What you will do? Sunday you will not study anything on Sunday. Friday. The council also has argued the matter. We have appellant. The council for respondent seeks time. Relist on 6th. Friday. Good question. Have you read the question of law? What is the question of law framed?
The best evidence aspect. And
It's,
respect to in the absence of the partition, D9 and D10. We speak about which are going to be the theories and may be the source of title with respect to particular the next. That is the first. Second question, my lord, whether the court will not specified in non-granting declaration in paper. Clearly, that is no payment property, inconsistent property. What was the need for it? What was the stating? Here in favor of the defendants, by the government, in spite of not discharging the burden by the defendants, that the property conflicts with them and earn the share of their credit. The courts will not justify in not creating the issues in this. Source of title of the courts will justify in wanting efforts in this. But production of by applying other that is
but have you read what is a substantial question of law framed by the court? Go through that. What you now read is not all the question of law framed by the court. Not all is framed. Go through this, then you'll understand what is the question of law. Put in my doubt.
Number 24.
It was called out the morning session. No representation on either side. That was called out again at 3:35 p.m. There is no representation on either side. Release this matter on 5th.
Appear for the appellant in this case, my lord. My senior is not keeping well, my lord. He is suffering from high infection, my lord.
Now the 25 Allah. Huh? 25 ಕರೆದ್ರ ನೀವು ನಿಮ್ದು ಯಾವ್ದಮ್ಮ ಕೇಸ
26 serial number, my lord.
ನಿಮ್ಮ ಫ್ರೆಂಡ್ ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನೇ ಐ ಇನ್ಫೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದು ಸ್ವಾಮಿ, ಐ ಇನ್ಫೆಕ್ಷನ್ ಆಗಿದೆ ನಮ್ಮ ಸೀನಿಯರ್ಗೆ. Kindly have it on 10 days time will be given, my lord.
No. Not even adjourning it for 1 hour. What to argue now? Your opponent is aged more than 95 years.
Please,
So,
my lord. 5 days time will be given, my lord.
No. You argue.
Last and final chance, my lord.
No. This is not civil court.
My last and final chance, my lord. Please, my lord. Sorry for apologies, my lord.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ You already argued once. You submit again, let us see what it is. The appeal by whom? May 1957 is the date of sale. Hmm. Hmm. The settlement dated? Hmm. Plaintiff and D2 are brothers. Hmm. You are appearing for defendant number 2. One. Plaintiff and defendant number 2 are brothers. Your defense, defendant number 1. You are the owner of the property. All right. Now, defendant number 2 executes a license, is it? Your property. Lessee. Plaintiff is a lessee. All right. Defendant number 1 issues a legal notice to plaintiff for possession. So you want possession from plaintiff. Hmm. Hmm. Did you issue the legal notice? '06 TP Act. Yes.
First forward, there has not been any. Even though it has been any, we have been by word saying what. There are no specifics. But we get that is the number two. Number two, no one is legal here because not on record. After during the night, that was the legal record. Because they did not dispute saying that we have not executed. And the legislative theory of 1967, it was very difficult. Four, one the 90 the result. Because I want to first in the head that the three in the series of
Filed under which provision? Filed under which provision? Old Act 99 Acts 21(1)H. That is placed on record. What is the additional evidence produced by the plaintiff? That anyway you are agreeing. It is fact that plaintiff was a tenant or lessee under you, that you are not disputing. Thus, that is why you issued notice for eviction under 106. It's a different matter that your HRC proceedings are dismissed. I don't know why. On what ground? What is the exhibit? The order sheet. What is section 29 of the Rent Control Act? So how the trial court has dealt with this? All right, let's see the judgment. Ah. Perfect. Ah.
Case regarding fraud. Like that God has deeded this business. Next company will not do that. Even though the rating is God, he has not studied the business. He's learning a lot of the holder. Before 1967, maybe 1 year beyond, he stepped into the boss and they is God. Also considered by the tribe of Bengal. They are God has been good, was suffered.
Oh.
I mean, well, because we are understanding.
Read further. The mortgage deed was executed in 1964. So you paid 500 rupees. Ready? So how you paid that? They have received in that by virtue of the document it is received. By, by what it is paid? How it is paid? Mode of payment? Illegible. Cannot be readable, at least by me. P6. Okay, so the registered sale deed. Heard the learned counsel, the Nataraj Ballal for Arpan, for reply, if any of the appellant, relist on 6th October. The continuation again, two other orders I already.
Number 27.
You can mention that, the time of argument and representation on behalf of the strong appellant. 412. Yes. Where is this Ravi Kumar? Huh? The partition suit, is it? This appeal is preferred by whom? The suit is decreed by the first appellate. Any request of law? Who has preferred this crop? Neve fifth. Indian crop. You are not a bona fide. No. What is the finding of the first appellate? That you are not a bona fide person. So why are you challenging by crop? Anything is gone against you. Let him come. ಇವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ? So what remains that you have not got it set aside. You have not got this order set aside. Recalled rather. So your crop won't survive. What is the order against you? They were held to be?
According to the government, 80% of the
What others? Checked it. You're not aggrieved by that. Correct. Matter is called out in the morning session. No representation on behalf of appellant. Counsel for respondents was present. The matter is called out at 4:19 p.m. The counsel for appellant is again absent. And no representation. Counsel for respondents are present and ready to go on with the matter. In order to provide one more opportunity to the appellant, released on 9th October, Monday.
Okay. Sir, yes.
That's Mr. Ravi Shankar. You're off. One and about 2 LRs. Somasundar. You're R1. Why are you standing in the appellate space? That's why I asked you are Ravi Shankar. Same order. Matter was called out, no representation by the appellant. Counsel for respondents were not present. Release this matter next week. Yes. Whose appeal is this? Plaintiff's appeal. Suit for declaration and injunction. Yes. But let the other side come.
Also, in that case also, the bonus of
Yeah. So both the courts have held in your favor. On this matter on 9th. Final. Still, about what is this 30th is over?